This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Adam Carolla.
Welcome to Beyond a Reasonable Doubt. Mark Garrigus in New York City. We have, hopefully, our technical issues worked out. This is going to be fast because I have to do an interview in 13 minutes. But Mark...
As do I.
Oh, as do you.
Who are you doing an interview with?
ABC Radio out here. All right, so let's get right to the nuts and the bolts of the Chauvin trial.
Okay, let's talk. The jury's out. There was the closing arguments were yesterday. The prosecution, as the prosecution loves to do, committed misconduct in what they in their presentation. They did effectively tug at the heartstrings, but many of the things they did were prosecutorial misconduct. Then the defense got up there. If you watched even I'll give credit, CNN Don Lemon actually admitted that the defense lawyer was effective. Eric Nelson was effective. Eric did something that I think I try to emphasize to new lawyers all the time. He laid out the facts. He laid out what the jury instructions are, and he laid out what the law is. That's what jurors want. I understand that the prosecution's presentation played better on TV, but at the end of the day, people, you're talking to an audience of 12, not to an audience of 120 million, although a lot of people would rather have it that way. But the interesting thing at the end of the day was that Eric Nelson made a motion for mistrial, and the grounds were that Maxine Waters was out there calling for confrontation if the verdict didn't go the right way. And apparently the verdict going the right way means she will not accept a manslaughter. She wants murder. And that was brought up to the judge, who was at first somewhat circumspect and then told Mr. Nelson in no uncertain terms, if there's a conviction, you've got yourself an appellate issue. Did you see this?
I did. Why did he say that out loud?
Why did the judge? Because
Yeah.
I think he's increasingly frustrated. This trial started off with his own, meaning the city officials there, the executive branch, announcing the $27 million settlement, which ended up getting two jurors dismissed because it affected them, said they couldn't be fair. If any juror heard this and thought, well, here's somebody who's a voice of the executive branch calling for basically confrontation if the verdict doesn't go the right way, then nothing will piss off a judge more, and I think rightfully so. I also will tell you that the idea that at least Biden today, when he said he called for a verdict, said the only reason he was speaking out is because they were sequestered. I just think it's that people have to understand, until it's your ox that's getting gored, so to speak, try to be consistent. If you have somebody, a loved one that's on trial, and that person is not popular, which most defendants are not popular, I don't think you want a rush to call for collective action and for the jurors to deliver the so-called right verdict if it's not based on the evidence. I just think that's a Stalinist kind of a method. And speaking of which, look at the dissident in Russia right now, where everybody's up in arms because he's dying on a hunger strike after he had a bullshit trial and sentence. And I'm not comparing Chauvin to a dissident in Russia. I'm talking about the process. And if you don't let the process work, then there is nothing. We don't have anything that separates us from the kinds of governmental institutions that we criticize.
So Maxine Waters went down to Minneapolis and started speaking about pushing back. And it's her normal rhetoric. She gets and stirs the pot. And, sometimes, again, there's an argument. You can say, well, she's not calling or inciting violence. She's just telling people to protest. But 10 minutes ago, she was saying Trump did it as it pertained to the insurrection. So it's kind of a tough argument to make for her.
Right. It's amazing. I guess we've mind melded. If you're a person who was condemning Ted Cruz, which I was. I thought what Ted Cruz did, especially for a guy who's Harvard educated and then pretends to be a man of the people. If you're criticizing Ted Cruz for January 6th, and rightfully so, then be a little intellectually honest and level the same criticism here, because both things, one was assault on the seat of democracy, any way you want to put it, if that's what you were complaining about, that rhetoric was something that was calling for insurrection. Here, it's you've got somebody who's calling for a conviction, not based necessarily on the evidence. I understand the Chelsea Handler interpretation of due process, but I don't think there is a right or wrong verdict based on popularity. It should be based on the evidence. That's what the jury instructions, that's what due process is all about.
Don't you think that the defense already had an argument for a mistrial even before Aunt Esther, as I know her? You guys know her as Auntie Maxine, but I've always known her as Aunt Esther from Sanford & Son. Before she started bloviating, just because of the general temperature, National Guard, businesses boarding up. If you were Chauvin's lawyer and you were defending him, wouldn't you think you had grounds enough for mistrial even before Aunt Esther spoke up?
Well, look at what you could put together on grounds for a mistrial. And by the way, I always have to say this because people just don't understand it. I'm not advocating. In fact, my whole professional life is anti-excessive force and wrongful death committed by police departments. I am, however, probably stronger. I've got a religious fervor when it comes to the system trying to work. Here you have, at the beginning of the trial, the announcement, as I just referenced, of a $27 million civil settlement. That wasn't even approved. There was no reason for that to be announced in the timing of it. Is it the right amount? Probably is. Should it have been announced at the incipient stages of the criminal trial? No way. Number two, you then have a prosecution which has repeatedly committed prosecutorial misconduct. And by the way, if you're somebody who wants to talk about the criminal justice system and how it's broken, I can cite you numerous examples in this case, not the least of which is that they sandbagged the defense and didn't turn over the carbon monoxide testing until the rebuttal phase. That is number two. Number three, if you have an expert witness who testifies for the defense, and within days, a house he used to live on has red paint sprayed all over it and a severed pig's head put on it to intimidate the witness, which sends a message to an unsequestered jury that we'll find you and hunt you down if you don't have the right verdict, which is what they will have.
He was out of state, by the way.
Correct.
Not even Minnesota.
And I've mentioned a couple of times the idea that we're importing California cops to opine on excessive force for you and me has a special kind of irony. But then you combine that now with a call for confrontation if it's not the right verdict. If that isn't grounds for a mistrial, I don't know what is. And so it is what it is. You get a conviction. All you've done is ensure that you're going to have years and years of litigation over appellate issues that somebody's going to have to grapple with.
When do you expect the verdict to come in, if you were guessing?
If I was guessing, by the time it would not surprise me if you start having questions today. I think you'll hit questions today or at the latest tomorrow morning. How
much will you know when you hear what the questions are, and will we be privy to the questions?
We should be privy to the questions, and I'm pretty good at that. I know a lot of people say it's reading tea leaves, but I've done enough jury trials to understand, given what the makeup of the jury is and the questions, to pretty much predict what I think I'm good at. So we'll see.
Yeah, I know when you pitch a TV show and they go, well, what kind of budget are you thinking about? That's a good question. And another question is, well, it's kind of like something we already have. Is it something that you could make shorter? Something? Yeah, you get the questions. I don't think it's much different than a date. Start getting questions about, do you like kids? That means it's going pretty well.
Exactly. Or how many kids do you already have? Right. I'm going to add them on.
So predictions now. Hearing give the defense a grade. Give the prosecution a grade.
I give the defense an 88, I give the prosecution roughly the same from a tug at emotions and heartstrings, which is, just because it's prosecutorial misconduct doesn't mean that it isn't at some level effective. So, they got away with it, basically. The judge only had to admonish them, however a number of times, and I think it's effective. It's all, at the end of the day, I have said this all along, the closing argument does not change any minds. Closing argument just enables or arms the people who are already predisposed to vote with you to get more effective arguments or arrows in their quiver.
I saw the lead a law expert, for lack of a better term, for CNN tweeting out that the defense made their closing remarks about explaining what the job of the jury was and what the definitions were and reasonable doubt. And she's like, you never do that. Is that true?
Yeah, the senior legal analyst, Laura Coates, former federal prosecutor. I like Laura. However, she tweeted out something that quickly became, a bad legal take. Then it was retweeted by two other senior legal analysts, both former feds and analysts at CNN. It's unbelievable to me that these people are putting out this nonsense and think that that's okay. By the way, the tweet, if you look at it, I retweeted it because it's just the bad legal take. It was something like, think about this. They talked about reasonable doubt, not that he's innocent. Oh, really? Well, what system are you working in? Because the last time I looked, that's not the American system.
All right, 30 seconds, Mark. Predictions.
I have not left my, actually, I tilt a little more. I've always said on the bell curve, about 80% is that it would be hung leaning towards guilty. I'm probably now 90% hung leaning towards guilty. I don't think those jurors, I think they're under a great deal of stress. And I think that it's just too fractious an environment to come back with a not guilty. And, I'm not saying that Chauvin necessarily deserves a not guilty in this. In fact, he's probably, in my humble opinion, based on the evidence, I think there's a compelling argument for his guilt. But it's been clouded or shrouded in so much theatrics around this that you're never going to be sure as to which way or what the jury is making their decision on.
And last 15 seconds. When you leave that courtroom, if you're a defense attorney and you have a mistrial in your hip pocket, is that a little get out of jail free card, or is it a little mulligan card, or how do you feel about that?
It never makes you feel better. I mean, the worst time for a trial lawyer is waiting for that jury. I can't stand it. I hate it.
How much better do you feel with a mistrial possibility?
The fact that he denied it would not make me feel good. I would have felt better, and I've had this happen where the judge says, Mr. Gargas, I'm going to take that motion under submission. We'll see what the jury does. Then you feel like you got a little something.
Thanks, Mark. I know you're under the gun, as am I. And
thanks, Adam.
Thanks, Gary, for your...
Thank you, sir. We'll be back on Thursday with another Beyond Reasonable Doubt.
Beyond Reasonable Doubt. Thanks.
Thanks for listening to Beyond a Reasonable Doubt. Stay tuned for more bonus episodes coming soon.